Hmm. Well, hello. Didn't see you there. Welcome to Uncivil Law, where we learn through the misfortunes of others. Hope you're having a good day. We are here with our continuing coverage of Toddy and Without a Crystal Ball, the story that does not end. You want to know a legal secret? Here's a legal secret. You cannot file lawsuits, and then once they're filed, you can also not just file things. It's true. You don't have to file all the things every time. You can file some of the things. You could file only the most relevant things. You don't have to file everything. That's an option. Just wanted to let you know, in case you're unaware. You cannot file stuff. That's a choice. Just wanted to make that clear, because our I don't even know what our twin antagonists in this case are continuing to poke at each other. I don't know. Here's another secret. Counsel can actually be civil to each other. They can actually have a spirit de corps and camaraderie. Even as they're fighting for their sides and taking every tactical advantage for themselves and their client, they don't necessarily have to, direct that exactly at the other attorney. These are options. Not options that we're employing, just helpful to know. So today we've got a motion of sanction from Brown towards Salts, because I don't know, what this fire really needed was more gasoline, I guess. So we've got this sanctions motion, and we're going to cover that and go over that now. So, yay, let's do that. So, okay. And I adjusted it before I started, and it doesn't look right, even though I adjusted it before I started. So now I look like I don't know what I'm doing, which is very sad for me. There we go. That's better. All right, defendant's motion for sanctions. Oral argument is requested. Really? Why? I guess they're going to tell us. On January the 13th of 2021, the plaintiffs filed a declaration of a non-party witness, Lori Barnhart. That declaration was full of salacious testimony aimed at publicly accusing defendant Catherine Paulson of perjury and accusing the undersigned counsel of very serious ethic violations, including attempting to procure false testimony from Ms. Barnhart. By plaintiff's design, the second declaration was almost immediately broadcasted to a massive social media audience, as is the thing that you're also writing, incidentally, because we're covering all the things because we're pot committed, man. We are pot committed, and we are covering all the things now. Miss Barnhart's testimony is demonstrably false in every material respect. Indeed, plaintiff's preparation, filing, and public promotion of it was defamation thinly cloaked as legal advocacy. When they prepared and filed this declaration, plaintiff's counsel knew the testimony was directly contradicted by a long series of recent emails between Barnhart and the undersigned, but they proceeded undeterred and withheld from this court the very emails that proved the falsity they had prepared. Well, they said that they would provide them to the court secretly, but they didn't want to disclose them because they were confidential. And then Brown turned right around and provided them, and we read them. And I came to the conclusion that Saltz's description of them was unfair and untoward. But this is true of both sides. Both sides are flinging mud at each other. The attorneys are flinging mud. So I agreed with Brown that Saltz seemed to overread the emails, and he overrepresented what they said. And now we're going to poke the bear some more, because I don't know. Further, they knew the testimony they prepared was directly contradicted by a separate declaration she helped prepare and was eager to sign on the behalf of defendants just 1 week earlier. It's not clear if they knew that or not, because it's not clear what emails Saltz had. So, yeah, you are assuming that Saltz had all the emails you have, but that's not a fair assumption at the time he wrote them. So that's not a fair assumption, as someone pointed out. We don't know what emails Saltz had. The only emails Saltz presumably had were the emails that Barnhart gave to Saltz, which are not necessarily all the emails. But you've reached the conclusion it must be all the emails and he must be defying them, which isn't necessarily the best conclusion, but all right. Further still, they knew, because Miss Barnhart told them, she was suffering from confusion, foggy, poor memory, and anxiety. Okay. Plans Council preparation and filing of this false testimony clearly meets the bad faith standard. Are we doing this again with the bad faith thing? And it's sanctionable. But the events leading to the preparation and filing are likewise abusive and improper, and underscore the need for sanctions to punish and deter this conduct. The second Barnhart declaration came after Plam's week-long effort to intimidate, threaten, and harass Miss Barnhart. Okay, so how did they exactly do that? All right. On December the 24th of 2020, they filed a declaration that included totally irrelevant but extremely sensitive and damaging information about Miss Barnhart's past, which was, by Plam's design, designed to be broadcast to a massive social audience, creating Miss Barnhart extreme embarrassment and her anxiety. How are you coming to the conclusion that that was their design? That was their purpose. They presumably knew it would occur, but to say it's their purpose is a different level of mens rea, as all of our people who know the model penal code will know. Knowing and purpose are two different standards. So they might have known it would occur, but did they want it to occur? Two different things. The model penal code teaches us. Aww. On January the 1st, Plans Counsel Michael Saltz sent a private message to Miss Barnhart, threatening that she could get in trouble for removing herself from social media in response to public blowback, but offering to let her go if she cooperated with him privately and voluntarily. How exactly did you know that? Is that in the record somewhere? You didn't give a footnote. Maybe it'll come up later. On January the 4th of 2021, Mr. Saltz filed a declaration in which he swore under oath that he personally conducted an investigation and determined Ms. Barnhart conspired with Paulson to hire evidence relevant to the lawsuit. These unfounded allegations were also amplified to a huge social media audience. Yeah, you don't know what Saltz knew. You don't know what his investigation was. You don't know what access information he had. So, you're assuming some things that are not necessarily correct. Miss Barnhart finally relented to this assault on the 12th, and she contacted Plam's counsel in an attempt to make the harassment stop. She told Plam's counsel she was represented by the undersigned in relation. Nevertheless, they proceeded to interview her for 11 hours. Really? Wow. So that interview costed like $5,000 unto itself. Which is a lot of investigation, incidentally. So if Saltz is saying we did a lot of investigation, 11 hours of interview is a long interview. Reviewed her emails with the undersigned, as well as her social media accounts. What emails did they review? You don't know that for sure. And published the results of those efforts. This is a clear violation of Rule 4.2. Required them to do the moment that they told them was represented by undersigned. Well, if she told them that she was represented, then yeah, that would be improper. So it depends a lot on what exactly they told her, or what exactly she told them. So, at the time. So, we don't know for sure what that is. This court should not tolerate this pattern of bad faith and abuse. Sanctions are warranted under the relevant law. I'm not sold on this. I think both sides' attorneys, I just want to sanction both attorneys. I want to even sanction Brown harder, because Brown seems to be the one primarily poking the bear. But this needs to stop. Didn't the judge just kind of tell them to stop like 5 seconds ago? If you keep doing this, I will get mad. And then Brown is proceeding to do it. He didn't get the memo. One of the wonderful things about being judge is you get to decide what is and is not important, as long as you're not abusing discretion. And if I were judge in this case, that would be great, because I get to ignore so many things. So many things are completely irrelevant to the issue I'm trying to decide. That's the nice thing about being judge. It's like you are literally the person who gets to decide what's important and what's not, tell it to the judge style. And you can be overruled for abuse of discretion, although it takes a lot, and you're in control of your case, and it takes a lot. So if I were a judge, what I'd be doing is just ignoring this and so many other things. I'd be like, yeah, I just ignored the last 30 documents you wrote because they had nothing to do with the issue I was trying to decide, which once again was jurisdiction. Remember that issue? Jurisdiction? That was the issue I'm trying to solve. I'm just going to ignore all this. Yeah. So, yeah. That's a whole bunch of money down the tubes. Oops. In November of 2020, Mr. Saltz engaged in a Twitter spat with Barnhart. In response to Saltz's many tweets about this case and about Paulson, Barnhart posted a tweet questioning whether Saltz was really a plaintiff's attorney. She asked because she didn't believe real attorneys try their case on Twitter. Okay. Mr. Saltz responded by challenging Barnhart to meet him in his office to discuss her tweet and threatening that he would sue over it. It's not quite what I read, but all right. He's engaged in similar tactics on other women. Oh, we're making this a sex thing now? Okay, we're going to say this is sexism-based. That's nice. He's engaged in similar attacks on other women who question his Twitter activity relative to the case, including threatening one that he would turn his prosecutorial attention on her because she'd asked whether, in fact, they were Westbrook's attorney. I think that's kind of overreading what Saltz wrote. Why do they, there is a good principle of having a conversation, a civil conversation with somebody, which is you want to take a charitable interpretation of what someone says. If you're always taking the least charitable interpretation of what someone says, you're going to have a bad time. So it seems like Saltz and Brown, and to a higher degree Brown, are dead set on taking the worst possible interpretation. So I wouldn't necessarily mind that as it relates to the facts of the case, right? Because that's kind of their job. Their job is to represent their clients. So their job is, roughly speaking, to make their side of the case look as good as possible and make the other side's case look as bad as possible. So if this was being done with respect to issues in the case, I wouldn't mind. That's kind of the job. But when it's being done to the other attorney is not a part of this case, really, strictly. They're not being sued. They're just a person to help facilitate. They're counsel. So it's like, do we need to really bring the other attorney into this? No. Why are we making them a thing? I don't know, but apparently we are. So, good times had there. On December the 24th of 2020, the plaintiffs filed their opposition to the motion to dismiss. They took the opportunity to harass Ms. Barnhart by revealing highly sensitive information about her. Information that has no relevance whatever to this lawsuit or defense motion. As opposed to what Brown did? Are you kidding me? I mean, Saltz tried to keep it out of the court, which you whacked him for, and now you're going to whack him for disclosing too much. What? They used this declaration of Kim Fulmer as a vehicle for this harassment. The ostensible purpose of this declaration was to support plaintiff's contention. The defendant Paulson knew she had a Washington subscriber to her YouTube channel. Just this court could exercise personal jurisdiction over her. Yeah, once again, if I were Katie's lawyer, I would have just conceded the point and said it doesn't matter for the reasons I've illustrated many, many times. Of course she has subscribers in Washington. It just doesn't matter. That was the right argument. Not, we don't have any subscribers in Washington. We never heard of a Washington subscriber. That doesn't even pass the laugh test. Much better. Yes, we have subscribers. It doesn't matter. Concede that and move on. However, the actual purpose is revealed to be abusive but otherwise irrelevant contents of the declaration. First and most egregiously, plaintiffs used the Fulmer Declaration to expose an 8-year-old criminal charge that was brought against Barnhart in an entirely unrelated matter. That charge was dismissed by the prosecutor, but plaintiffs omit that fact from the declaration. Second, Fulmer included details of her side of an 8-month-old Twitter fight that she had with Barnhart. As kind of you do in a declaration, you express your point of view. It's what you do in declarations, yeah? In which she stated that she knew people in a biker gang who would defend her if she were attacked. Ms. Fulmer did not mention the abusive tweets to which Ms. Barnhart was responding. She testified with no credibility that because of a tweet an 8-year-old charged she was afraid of Barnhart and Paulson who would physically harm her or her family. Well, if she felt afraid, she felt afraid, but I wouldn't necessarily put it in the declaration. Finally, Fulmer declaration exposed the entire work address and direct phone number of that person they believed to be Barnhart. We're really getting into like exposing people online, really? Okay, that's an interesting idea. Neither the 8-year-old later dismissed criminal charge nor the Twitter exchange has anything to do with personal jurisdiction under this lawsuit. You know, again. If we're going to start talking about things that have to deal with jurisdiction and this lawsuit, if we're going to start talking about things that are relevant to jurisdiction or this lawsuit, when was the last time we had anything relevant to jurisdiction or this lawsuit? When was the last time we discussed anything relevant to jurisdiction or this lawsuit? It's been a little bit now. It's been a little bit now since we discussed anything that's relevant to jurisdiction or this lawsuit. Saltz is bad because he filed things not relevant to jurisdiction. Okay. All right. That's okay. Good. These could only have been included to harass, intimidate, and punish Barnhart. Likewise, the inclusion of Barnhart's contract information, not even partially redacted, was unnecessary for the ostensible purpose of the declaration. It was only exposed to expose Barnhart to unwanted public contact and expose the contents of the declaration to her employer. With respect to the goal of harassing, threatening, and punishing Barnhart, the declaration was a great success. As soon as it was filed, Saltz's social media friend and ally, Emily Baker. That's funny. I that's kind of funny. I don't mean disrespect here to Emily. I just find it humorous the way we're phrasing this. The ally and social media friend. It covered line by line on her YouTube channel. I mean, not to put too fine a point on it, but if we're going to go after internet commentators who are reading the things line by line on their YouTube channels, just saying. Just saying. I don't quite understand why we're so desperate as Brown. Why are we so desperate to make Emily an ally of Saltz? Even if it's true, why are we trying to do it? Which I don't think it is true, but why are we doing this? I don't know. Okay. I don't know. She observed that plaintiff had been exposing embarrassing information about Barnhart in part because she had riled Mr. Saltz in their Twitter exchange. It's not exactly what Emily was saying. This is just, you know what the takeaway lesson here again is, folks? You know what the real takeaway lesson here is? And I think we can go officially into hashtag this is legal advice. Don't use Twitter. That's really just the clear mission of this. That isn't to say don't use social media. Use Facebook or use Instagram or use a TikTok. Don't use Twitter. That's the real lesson that we've all learned. Don't use Twitter. Twitter sucks. I don't know why Twitter is such a horrible place, but apparently it is. Don't use Twitter. Twitter's garbage. There's an opinion for you. How about that? That video has been viewed more than 150,000 times. Okay. As plaintiffs intend, the social media assault on Barnhart, which required only the public broadcasting of Fulmer's abusive and irrelevant testimony, which is extremely upsetting to Barnhart. With respect to the exposure of an 8-year-old criminal charge, she lamented, "The only thing I want to keep private is they've spread all over the internet." In her email, she explained despairingly, "Thousands of people hate me. There are videos that will never go away and documents spread all over the internet that will never go away." Yet another, she explained, "I've had personal information shared about me, videos berating me, fearful of my kids' and grandkids' safety, my safety. Had to deal with these issues because of issues 8 years ago." Miss Barnhart made contact with the undersigned via email on the December 24th. She explained that she understood the undersigned was Miss Paulson's attorney and stated, "I'm writing to you because the opposing counsel has been harassing people, including me on Twitter, and has brought it up in recent filings." That is language that she used. That's fair. Whether or not that's accurate language is debatable, but it is what she said. That's true. She went on to explain, "I've done nothing illegal here, and this attorney, Mr. Saltz, took it upon himself to dox me in his latest filing, which has been reviewed on YouTube by numerous people." We can quibble or not with whether Saltz did that or not. The email began to extend a conversation between Barnhart and the undersigned that would span 18 days and some 150 emails and phone calls. We definitely saw a lot of emails and phone calls, so, yeah, we got the picture. In an attempt to escape the public harassment then ensued from the Fulmer Declaration, Ms. Barnhart took steps to remove herself from social media. Saltz learned that Barnhart had done this. On New Year's Day, he also learned from a friend of Barnhart that Barnhart was suffering health problems due to the following of the Fulmer Declaration and ensuing harassment. The friend pleaded with him to leave her alone. "You're causing harm to her health. Please, I beg you, leave her out of this. Leave Brittany alone." Instead of backing off, Mr. Saltz responded by intensifying the intimidation. This is a very aggressive way of framing the things that Saltz did. It's like, it's kind of true, but it's very aggressive. And why? The same day he learned about compromised health, he sent direct messages on Twitter to Barnhart, asking that she deliver to Barnhart on his behalf the following threat. Barnhart could get into trouble if they do not cooperate and tell us what she knows private and voluntarily. But Saltz wanted to avoid all that, find out what she knows, and let her go. I think we're overreading what Saltz is doing, personally. I think we're assuming a lot of malice that isn't necessarily there. Just one man's opinion. And why are we ascribing the worst possible interpretation to this language? I don't know. On January the 4th, 3 days after sending this, Saltz filed a Cinta Marie says, "We've already heard all this." Man, if you're looking for new things in this case, I don't know what to tell you. Yeah, is this repetitive? Yes. What do you want from me? It's the legal document that was filed. It's repetitive. So you get to hear it again and again and again and again and again and again and again. On January 4th, 3 days after sending this, Saltz filed a declaration swearing that he had not sent Barnhart any direct messages, let alone messages of harassing or threatening nature. And that's true. Not surprisingly, Barnhart took the January 1st messages the way they're intended, as a threat. You're implying intent, but okay. She removed herself from social media in an attempt to shield herself that the plans had instigated with Fulmer. But now she's being threatened by the very architects of the harassment, with legal liability for having done so. Plans have her in a vice, and we're not yet finished closing it. I'm a bit of a sucker for the purple prose and the imagery language, so I do like that part from Brown. When he says they're in a vice and not finished closing it. Some people might find that a little cheesy. I kind of like it personally. So if you think it's cheesy, I understand. I kind of like it. I just wish it wasn't being done to go after a different attorney in the case. So, one can disagree or agree about the relative value of imagery laden language, but I kind of like it. I just wish it wasn't being done in this particular instance. Mr. Saltz intensified his attack on Barnhart even more when he filed his own declaration. The purpose of his declaration was to swear under oath that he had personally conducted an investigation and was able to determine Barnhart and engage in a concerted effort with Paulson to hide evidence of known connection between defendants and a person known to me as Laurie Ann Barnhart. Yeah, that is what Salt said. And from his point of view, that might have been completely true. Because, again, we don't know for sure what emails Salt's had. Because presumably the only emails he had at the time were the ones that Laurie Ann gave him, which might not have been everything. So we don't know what Salt's did or what his investigation revealed, which, again, isn't necessarily what's true. Near, for that matter, is Brown's, but, you know. To the 872 of you who are currently watching this, thank you. And if you'd be so kind as to remember to give it a like, I would appreciate it. You know, give it a like, give it a subscribe, leave a comment. All those YouTube things help the channel grow. It's appreciated as always. Thank you. And I'm thankful for every one of you being here. Plaintiffs must have known that Salt's determination had zero evidentiary value. It goes to his motive. And would do nothing to advance their personal jurisdiction argument with the court. Again, I don't know how... maybe we should just take a shot. Maybe we should just take a shot every time they say, this does nothing to advance jurisdiction. So they do nothing to advance jurisdiction is the secret word of the day. Take a shot. Because... yeah. So every time they say, this is not relevant to jurisdiction, we're going to take a shot together. You and me. This court was not the intended argument for the Salt's declaration. As plaintiffs intended, the unfounded sworn declaration of Barnhart and Paulson's guilt was broadcast to huge social media audiences. She was angry, but also despondent over being targeted for such brutal attacks that she had done nothing to deserve. She explained in an email, everyone believes what Saltz is saying about me. Over 1 million people know about me. In another, she wrote, I've already been tried and convicted. Barnhart was convinced that she was going to be sued and thrown in jail simply because she exercised her rights to remove information from social media. She wrote to the undersigned, I hope a judge sees what they do to innocent people. Okay. Barnhart and the undersigned had discussed the possibility of submitting a declaration from her describing the abusiveness of the Fulmer Declaration, Mr. Salt's threatening messages, her baseless accusations in her declaration, or his declaration, and the very limited nature of her relationship with Paulson. She was understandably of two minds. On the one hand, she feared it could provoke even more abuse. On the other, she wanted to do something to defend herself and make it stop. On January the 5th, she agreed to proceed with the first Barnhart Declaration. That day, entirely on her own, she prepared and sent to undersigned a lengthy statement describing her involvement or non-involvement in this lawsuit, which is true. We saw that. It appeared to be based on the email record, not solicited. It appeared to be something that she just did. It was about 2,000 words. We read it. It definitely backed up Brown's narrative. It backed up Brown's prepared declarations. So yeah, we saw that. That seems to be what the record supports. Her limited relationship with Paulson, yes. Her Twitter exchange with Saltz, and the abuse she received, yes. That's fair. That's fair. That's what that said. It was unsolicited, as best we can tell. The undersigned then used that to prepare a draft declaration, which does seem to be in conformity with the declaration, which he sent to Barnhart on the morning of the 6th, cautioning her to review it and not assume it was accurate. That, is fair. That is what he said. Ms. Barnhart reviewed and suggested drafts. That does seem to be true. After an exchange of emails, the undersigned prepared a second draft to include her edits and additional changes and sent it to Barnhart, again cautioning to read it carefully and propose changes. Barnhart reviewed and suggested a correction to this version. And then she emailed the undersigned to ask if he'd sent a final version. 2 minutes later, the undersigned emailed the final version. Because she didn't have a scanner at home, she proposed different ways she could sign and return the signature page. We read the email exchange on a previous stream. That does seem to be accurate from Brown's point of view. So this seems to all be true. She offered to drive to a local store when they had a scanner. Yeah. She proposed having a friend of hers email sign the undersigned. She proposed using a signature app. True. But realized it required her to print the signature page and her printer was out of ink. So she offered to drive to the store to refill ink. That's all true based on the email exchanges we saw. At 6:29, the undersigned emailed Barnhart to explain he thought it best not to file her declaration. That's true. Her response is, okay, whatever you want to do. Walmart's 10 minutes from me and I don't work up, so I'm all night. Okay. She then asked if she needed legal side paper. Yes. Over the next 24 hours, Barnhart continued to offer additional information for the declaration. That's all true. That's all true based on our prior reading. We read the email exchange. We read the whole thing. In laborious detail, we read it. And yeah, that's accurate. Laurie Ann was working with Brown. Laurie Ann sent what appears to be a completely unsolicited, approximately 2,000-word narrative of all the things that happened. Brown prepared a declaration that was in keeping with it, was conforming to it. I saw no problems in the declaration. We saw Laurie Ann apparently ready to sign, making corrections, offering to get printer ink and all the rest of it. So that does seem to be true. Now, what we don't know for sure is whether or not Saltz knew any of that. Because the only way Saltz would know it is if Saltz had those emails, and we don't know what Saltz had. So Brown is assuming knowledge from Saltz that Saltz didn't necessarily have, because it's quite possible that Laurie Ann didn't give Saltz everything. So, I mean, it's at least worthy of consideration. So, that's one way to reconcile this. I mean, I wouldn't know for sure, but you could just call up Saltz and be like, hey, did you have all these emails or not? And, Saltz would hopefully tell you the truth one way or the other as an officer of the court. So, but no, we don't believe in picking up the phone. We believe in filing declarations and precipes and other things that hurt my soul a little bit. On the evening of the 7th, the focus of the emails between the undersigned and Barnhart shifted to the topic of plaintiff's efforts to subpoena emails and social media records. Barnhart's anger and anxiety worsened at the prospect of responding to the subpoena. I don't know if I describe her as angry, but concerned, yes. She was very worried that, as Saltz had expressly threatened, she'd get into trouble for having removed information. She's convinced that Saltz's abusive conduct wouldn't stop, and she became convinced that what she's doing to her must be legal because he's a highly successful attorney that wins all of the cases. That's a bit aggressive way to characterize it, but fair to aggressive. She became concerned that she'd be added as a defendant because of her biker gang tweet referenced in the Fulmer Declaration. They have used me to be the violent one. Since I lashed out, I said those comments. Barnhart's emails began somewhat confused and her tone more despairing. Yeah, that's kind of fair, I guess. She and worried she'd be put into jail over this, but she said jail would be better than torment she'd be subjected to. Fair enough. Barnhart called the plaintiff's counsel on January 12th. Plaintiff's counsel on admission, when she called them, she explained that she believed she was represented by undersigned in connection. But she's not a party, but she's represented. So, yeah, you shouldn't be talking to them in that case. Nevertheless, plaintiff's counsel did not contact the undersigned. Well, it depends. It depends on so many things, because, yeah, you can't talk to a represented party, but if they want you to be their new attorney, you can. So you can't, you definitely can't talk to a represented party. That's for damn sure. So you can't talk to the other party directly. Can you talk to a third party? Technically, yes. You probably shouldn't, but it's not illegal. And so they're not a party to the lawsuit. So, I mean, either way, what they did is fine. It's within the ethics rules as far as I can tell. So, yeah, what are the actual ethics rules? Let me just read them again, because it's been a while since I read the ethics rules, and that's always a good place to start. What are the ethics rules on this point about contacting a represented party? Let's consult the model ethics rules. Let's see. All right. Rule 4.2. In representing a client, a lawyer shall not communicate about the subject of the representation, with a person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has consent. So yeah, if Brown knew all that, then he'd be in violation of Rule 4.2. Yeah. So so Salt is representing Toddy. So in the course of representing Toddy, Brown shall not communicate about the subject of the representation with a person that Salt knows is represented by another lawyer in that matter. So if he knew all that, then he'd be in violation of 4.2. It's always good to double check the rules when you're not sure. So, yay, we double check the rules and now we know. I've never had it come up, so I was not familiar with what exactly it reads. But yeah, that's how it reads. Okay, great. All right. Nevertheless, plaintiff's counsel did not contact the undersigned. Indeed, by their own admission, indeed their boasting, they immediately interviewed Barnhart with respect to her involvement and communications with the undersigned, and review of all the emails. So unless Barnhart made it really clear really fast that they didn't want to be represented, because the client can always make that decision, but still, there's something in there. But I still, even though there's something in there, I still wouldn't be I wouldn't be resorting to this. I just don't think it's necessary or helpful. So I don't really approve of this entire thing. So because it would matter a lot if they were a principal. So it would matter if it's the client. That would matter a whole ton. So if it's the client and you talk to them, the other client, you're going to have a really bad time. So if I, as an attorney, call the other attorney's client, I'm going to have a really bad time. But if I'm talking to this random third party who might be a witness, Also, Brown can't really have it both ways. That's another problem. Brown can't have it both ways. Because the way 4.2 is written, it's factual. If the attorney was representing, Brown says that he wasn't representing Lorianne, which means that Saltz can't be in violation of 4.2. So that means I have to modify my legal opinion as a result. So yeah, I have to modify my legal opinion. Saltz can't be in violation of 4.2. It's not possible. Because even if Lorianne said I was represented, the way 4.2 is written is factual, if they were represented. And Brown says it's not true. So you can't be representing if you say you're not representing. Brown can't have it both ways. So even if Lorianne said I'm represented and Saltz talked to them, if that's not in fact true, it's not a violation of 4.2. So it would be one of those situations where you think you're breaking the law, but you're not. Or you think you're breaking the rule, but you're not. The way 4.2 is written, it has to be factually correct. And we covered this recently on a live stream dealing with a lie to the FBI that wasn't really a lie. So a person tried to lie to the FBI, but unfortunately, or fortunately for them, what they said was actually true. So their intent was to lie to the FBI. They tried to lie to the FBI, but they actually said something that was true. And the government tried to convict them, and the court's like, no, you can't do that, because what they said was true. They might have been trying to lie, but they failed. They failed in their attempt to lie. And so they didn't tell a lie. They might have been trying, but they failed. And so it doesn't count. So same thing here. It's like, yeah, same thing here. Saltz may have been trying to violate Rule 4.2, but if Lorianne's not represented, which Brown says repeatedly, I never represented Lorianne, then he can't be in violation of the rule. Even if he knew it, even if he was trying to violate the rule. So you can't have it both ways, Brown. Pick a side, man. So yeah, you can't have it both ways. And Brown never said he told Saltz. Yeah, it wouldn't matter. It wouldn't matter what's true in reality, but yeah. After an 11-hour interview with a person they understood to be represented by opposing counsel, but they weren't represented. You said that repeatedly. They weren't represented. So they may have understood it, but they weren't in violation of the rule because they weren't in fact represented. Because you said they weren't. You can't have it both ways, man. You can't have it both ways. Plaintiff's counsel hurried, prepared, and procured signature to the second declaration. Remarkably, they later explained that Barnhart told them she was confused, had foggy thinking and memory, was taking medication for mental health that interfered with her memory and thinking, and was experiencing a great deal of anxiety, which exacerbated it. Which is all relevant information. I mean, okay, why not? Okay. Plans counsel explained they had to rush to complete the interview and secure signatures because they told them they'd take medication for anxiety that interfered with their ability to think. That might be a reasonable thing to do under those circumstances. See Maya Ruin gives me $10 and say, this is effing painful. You have my sympathies and an alcoholic beverage on me. Well, thank you, see Maya Ruin, because you can see me ruin real fast over here. There was, I think, another super chat too. $10 from Holly Michelle. For your bourbon, thank you. You're going to need some more if you're ever taking shots when something's related to jurisdiction. Yeah. If we have something on jurisdiction, we got to take a glass. Got to take a shot. This is a personal thing. And I wouldn't expect every attorney covering this to have the same reaction to this, but I really personally don't like it when attorneys go after each other because it's so unnecessary. And it's like we're supposed to have camaraderie and spirit de corps and the whole rest of the thing. So I really, really don't like it when attorneys go after each other unless you really have to. And so that's what bothers me. Other attorneys may not care, and they might care about different things. But for me, as a commentator, I don't like seeing this. It's like, remember that Salts is not Toddy. That's all you have to remember. Salts is not Toddy. And for the matter, Brown is not Katie. So if you're Brown, just remember, you're not Katie. They're different people. Thank God. You don't have to bring this fight between the attorneys. You can have the clients fight each other all day long. But you don't need to have it be a fight between the attorneys. It's not necessary. It's not becoming of the profession. Having secured what they wanted from Miss Barnhart, the evening Salts took to Twitter to thank Barnhart and call her. The same woman had 8 days been publicly accusing her of Hyde Evans as a class act. Yeah, because now he's on her side, so of course he did. Why not? All right, so now we're going to get into the law. The law provides that a court may order any attorney or other person admitted to conduct cases who multiplies the proceeding in any case unreasonably and vexatiously to satisfy costs. That's true. So if you have someone who's just inflating costs, they can be ordered to pay. But that requires a pretty big trigger. And we're trying to pull that trigger now? Seems a little much. When ordered, these sanctions must be accompanied by finding the sanctioned attorney acted recklessly or in bad faith, or committed intentional misconduct. Those are some pretty big words there. Recklessly, bad faith, intentional. This is some pretty big words. Do we really need to be casting these kinds of aspersions? The court has inherent power to sanction misconduct and extends the full range of abuses and willful improper conduct, and is not limited to abusive court filings. That's true. Courts have lots of power. Yep. An award of sanctions under the court inherent powers requires the litigant to have acted in bad faith, vexatiously, wantonly, or for oppressive reasons, delaying or disrupting litigation, or has taken actions in the litigations for improper purposes. For purposes of imposing sanctions under inherent power, a finding in bad faith does not require that the legal and factual basis prove to be totally frivolous. That's true. Bad faith and frivolous are not exactly the same thing. That's true. Rather, sanctions are justified when a party acts for improper purpose. Fair. That's true. Even if the act consists of making a truthful statement or a non-frivolous argument. That's true. You have to do things for legitimate purposes. I don't really think, personally, that Salts was doing it illegitimately. I mean, I don't know what's true in reality, obviously, and maybe we'll find out what's true in reality from Salts' response here, and maybe that's what the point is, to get Salts on the record. Maybe that's the point of all this, although I can't fathom why we care. But maybe we'll find out what's true in reality. But I wouldn't necessarily go to the worst possible conclusion. What's the bourbon of the night? Tennessee is Jack Daniel's Honey is the bourbon of the night. And it's going pretty well, I must say. So, Good stuff. Recommended. As explained above, plaintiffs decided to publicly expose extremely sensitive and highly embarrassing information regarding Barnhart in the Fulmer Declaration without any legitimate need to support their declaration. Again, Brown is much more guilty of this than Saltz. If we want to say that, like, we exposed information about Barnhart, I mean, come on. They tried to compartmentalize it. I mean, Brown went much, much further. It's like, it was Saltz who exposed it? Really? Second, the fact that Barnhart was charged with a crime in Washington in 2012, 7 years before the events took place, in matter totally unrelated, does nothing to establish jurisdiction. Sorry, it's time for a shot. Okay, it's mentioning time. It's mentioned again. They mentioned personal jurisdiction again. So fill up your glasses, take a shot, guys. Oh. Third, while the fact that Miss Barnhart works for the Washington Department of Transportation may have helped to prove that she's in Washington, which she doesn't, incidentally, there was no need to include full email and direct telephone contact in order to establish that fact. Mr. Saltz acted for oppressive reasons and an improper purpose when on January 1st, he delivered to Barnhart the message that she could be in trouble for removing her own information from social media, but she could avoid all that and would let it go if she'd cooperate and speak privately and voluntarily. You like Jaeger? Okay. I mean, you know, fair enough. Also sanctionable is Mr. Saltz's sworn testimony. They never sent Barnhart any direct messages, let alone any messages of harassing or threatening nature. The first part of the statement is misleading. Saltz sent the message through an intermediary. The second is simply false. The messages are a clear threat. She could get in trouble if she did not do as instructed. Miss Barnhart took them as a threat, describing them mere threats directed at me and basically telling me cooperate else, which is something Barnhart did. That's true. We're discussing our drink choices in chat now, so let's discuss our drink choices. Let's discuss our drink choices in chat for a while, because why not? We can do anything. Someone said, I love Jack. I have all the special editions like Sinatra, but the Conte and deck of cards are driving. That's cool. Jaeger, someone said. I'm not a big fan of licorice, but I understand. Tequila? I only like aged tequila. Unaged tequila I don't like. But if you get me a good añejo, I'm in. Crown Apple? Not a big fan of Crown Royal myself, but, you know, if you like that thing, it's cool. You know, I don't look down on anyone's choices. The best whiskey is the one you like. I'm just telling you about my choices. But if you like Crown, man, you know, awesome. That's great. No shots over 100 proof. Let's be responsible. We could break out the 101. Do you want to do some shots of 101? Because Mary said no shots over 100 proof. We could do some shots of 101. That'd be good. We could finish whatever in the glass, and then we could do a shot of wild turkey. Let me know if you think that's a good idea. Shame on you, Uncivil, for forcing you to drink Long Island iced tea. Not great as a shot, but, you know. Coca-Cola and Gatorade. Concord Cosmo. I'm not familiar with a Concord Cosmo. What is the Concord Cosmo? That sounds awesome, though. What is that? I've got to look that up. Oh, Contral. That makes sense. An orange liqueur. Vodka, orange liqueur, and grape juice. I like it. I'm going to have to try that. That sounds promising. I like that idea. Vodka, orange liqueur with grape juice. That sounds promising. Nice. Someone has Basil Hayden. Basil Hayden is a fine choice, not a personal favorite. Blanton you might like as well. Let's see. KJ is streaming on her platform. Rosé all day. Hey, if you get a dry rosé, I'm definitely in for that. Bud Light kind of girl. Maker's Mark. I like the 46 better than regular's Maker's, but yeah, I'm an ambassador for Maker's Mark, so that's cool. Red Zin, absolutely. Red Zin, not White Zin. Kylie, I'm with you. Red Zin is my favorite wine, or my favorite red wine. Red Zin is my favorite red. So Kylie, you and I are simpatico on that. Beer and Jaeger, vodka, Tennessee Fire, Alberta, classic rum and Coke. That's nice. Cranberry Club and Coke. Yeah. 19 Crimes Merlot. Not bad. I've had it before. Pig Whistle. Not a big fan of Pig Whistle because it has too much rye for my taste. But it's okay. Or Whistle Pig. KJ is streaming your live stream on her platform right now. Oh, okay. Well, hello, KJ, for streaming my live stream. Good Malbec. Cava. Pappy Van Winkle to cook. Oof. Someone must have not been a big fan of that one. I think Pappy's vastly overrated, but yeah. Tears and Club Soda. Vodka Club. Southern Comfort. Dr. Pepper. That's a nice one. That's a nice choice. Prosecco. If you're in the mood. White Russian. I love a good White Russian. Hard cider. Whistle Pig whiskey, not a personal strong fave. Okay, cool. All right, let's move on. Maybe she didn't like that. Maybe KJ didn't like the alcohol talk. Sorry to I guess apologies to Katie for talking liquor if that's the reason you stopped the stream. So sorry about that. Soju, yes. Three Wise Men, Bloody Mary, I don't like Bloody Mary. No, I'm not a huge fan of tomato. Mr. Salt's testimony: they determined Miss Barnhart and Miss Paulson engaged in conspiracy. I'm sorry to Katie if she was rebroadcasting my stream on her platform and killed it because of the alcohol talk. I'm sorry, Katie. I didn't mean to. Baby, come back. You're like a fool to me. Something there about you. Baby, come back. Ooh. You can blame it all on me. I was wrong and I just can't live without you. I'm sorry, Katie girl. I didn't mean to do you that way. Please come back to me, girl. Is there any merch of Katie's that I could pimp? Does Katie have merch so I could pimp some Katie merch? Let's pimp some Katie merch. Does Katie have merch? Does Katie have some merch? August Gem says, marry you? Hey, I am single. So contact me on Discord. We can talk. Does Katie have merch? So I can pimp some Katie merch. We've done a lot of Toddy Beauty commercials. Can we do a Katie commercial? Should I go to her website and find out some merch I can pimp? Let's find some merch I can pimp from Katie Joy. Let's find some merchandise. Where is her merch store? Does anyone know where her merch store is? Why am I so submissive? You guys, Elian doesn't know what's going on here, man. Where's her merch store? I need a link or something. Joyfully unavailable. Let's see what I can do here. Oh, shopping? Maybe if I go to shopping, I can find it. Joyfully unavailable merchandise. Okay, this is looking more promising. Why can I not find her merch store? I just keep coming back to her Twitter page. Come on. I'm trying to do some Katie Joy Paulson promotion right now. Damn it. She sells a shirt that just facts and joyfully unavailable. Okay, we'll go with that. Okay. My friends, I think it is very important that you have a shirt that happily recognizes your status and really expresses your commitment to a relationship. And so, for that purpose, might I cheerfully and full-heartedly recommend the Katie Joy Paulson shirt of Joyfully Unavailable. Because, it's really important to celebrate those relationships and really express your commitment to your significant other and show them that how happy you are that you're unavailable because they're in your life. Joyfully Unavailable shirts, courtesy of Katie Joy Paulson. There to spread the message of joy that is in your life. Yeah, it's not bad. Mr. Salt's testimony that he determined Miss Barnhart and Miss Paulson engaged in conspiracy to hide evidence. Just facts and right, not just facts, it's not facts. Where's my hat? I don't wear it all the time. He certainly knew that the court would give no weight to his private investigation or determination of Miss Barnhart and Miss Paulson's guilt of the crime. But he also knew that the social media audience would take it as a strong, even conclusive evidence, and will exasperate the public vitriol against Miss Barnhart and cause Miss Barnhart, who we already know to be suffering health effects because of social media he engineered. Rule 4.2 is clear. In representing a client, a lawyer shall not communicate about the subject of a representation with this shall be good, because Brown is going to have to presumably try to take a side on this issue. So this should be really, really good. If I'm Salt, I can drive a fucking truck through this. So this should be good. How are we going to have this? No, Katie isn't. Yeah, Katie is asking for sanctions, yes. I think in these trying times, it's more important than ever that people help to support Katie Joy, because she has been going through so much as a creator, and to have her income stream diminished and her talent not fully realized because of constraints she feels, I mean, it's just a completely unfair thing. I mean, as a YouTube creator myself, I can't begin to express how frustrated I would be if I felt constrained in my ability to express myself on my channel. So I think what everyone needs to do right now is go over to Katie Joy's channel Without a Crystal Ball and subscribe. Because I think we really need to show support in these trying times to someone who's only trying to create at a time when someone's trying to silence them. I mean, this cancel culture thing has got to stop. We got to support Katie Joy Paulson together. I believe together we can make it happen. The rule applies even though a person represented by a lawyer initiates or consents to the communication. Oh, man. A lot of no's in the chat. A lawyer must immediately terminate communication with a person if, after communicating on the channel, the lawyer learns the person is with whom they're communicating is not on the rule. But by Plants counsel own admission, Barnhart told them she is represented by undersigned in relation to the case. They made no effort to contact the undersigned. Indeed, in the space of one day after initial contact with her, they proceeded to interview her for 11 hours, review all 150 of her emails with the undersigned, and obtained her full access to social media. The chat is going insane. This is fun. I like this. Review of all 150 emails with the undersigned and obtained from her full access to social media. Prepare a declaration that contradicted what they just reviewed. Secure sworn oath, file it, and promote its broadcast to a massive social media audience. Defendants disagree. The undersigned acted as Miss Barnhart's attorney. You can't have it both ways, man. You can't do it both. You can't have it both ways. You can't violate the rule unless you're actually representing. I mean, come on. Plans counsel's intent to violate the rule in aggravated dramatic fashion will remain. Oof. Why? Who cares, man? Oof. Okay. You know, my friends, it is so important that we watch everything Katie Joy has to offer because she has so much wonderful content on her channel and is doing nothing but helping to express her views. And I really think that we should all go, after this stream is over, and we should go watch Katie Joy together because she's speaking from the heart in a place that we really need to recognize. And to really help make sure that we have the willpower and the energy to get through those videos, as we should, to make sure that we have the full stamina, might I recommend Toddy Beauty Vitamins and Halo Beauty. Halo Beauty Vitamins, they're to help give you the energy that you need and stamina that you require when you're watching Katie Joy videos. Halo Beauty, there for all the Katie Joy fans in the YouTubes. One second for a second. The testimony Plaintiff's counsel procured in the second Barnhart declaration reads like a mirror image recantation of the first declaration. It also is clearly contradicted by the 18-day, 150 email record of communications between the undersigned and Barnhart. Plaintiffs deliberately withheld these emails when they filed the Barnhart declaration, despite the fact they purport to characterize them in the very document. Yeah, I'm not gonna rate Emily, obviously. No, obviously not. I love Emily, and I was already streaming, but we're not gonna rate her, obviously. So please don't rate Emily. I'm asking. Thank you. The numerous contradictions between the second Barnhart declaration and the email record and the first Barnhart declaration are summarized in the table attached to Exhibit E. These contradictions are critical in part because they fatally undermine the credibility of the declaration, but the real damage is wrought by Barnhart's declaration, as well as Plaintiff's other abusive declarations before it and after it took place outside the court. Plaintiff's filing was extremely effective in accomplishing the goal publicly, smearing the Paulson and the instance of the undersigned as well, of perjury by Paulson and multiple serious ethics violations by the undersigned. Paulson's actual motivation for filing the declaration is revealed how precisely they coordinated that filing with social media. You know, this is actually a serious aside. This is actually a serious aside. But I actually very, very much support my fellow creators, including Emily. And I will make that absolutely clear and absolutely plain. I think that there's a hunger for this content that is not being satisfied by the current market. I think there's a lot of people who want this who don't know it exists. And I'm speaking not just of myself, I'm speaking of the entire YouTube laws. I mean, I think there's a lot of people who don't know this exists. And so I'm working under the rising tide rises all boats kind of philosophy. So I absolutely support Emily, and it's 100% from the heart. I really do. And it's not out of disrespect that, but I was already going, and obviously I have to finish. So, but feel free to tune in to Emily if you like. She's a fantastic creator too. Plant's actual motivation for filing this declaration is revealed by how precisely they coordinated the filing with a social media campaign. I don't know about that. At 5:01 on the 13th, Saltz branded the social media audience by saying, "Thank you, Lorianne. You're a class act." That tweet got immediate presence from Saltz. He knew his audience had been publicly smearing and harassing. 1 minute after the tweet, Plants filed a second declaration. Salt's social media ally and friend, Emily Baker, seems a little bit much, did a 2-hour video covering that filing with near perfect credulity to an audience that now has reached over 110,000 people. During the parties meet and confer regarding the motion, the undersigned asked Plants counsel why they procured testimony from a witness who so flatly contradicted. Their answer was astounding. Okay, so they had a conference. Interesting. So this is why we're going to say, all right, so we're going to try to get a little bit more into Saltz's head here. Apparently. They argue that Miss Barnhart told them she's confused, has a poor memory, suffers from foggy thinking, especially when she's taking medication. This, they insisted, explained why they told the undersigned a false story and was eager to sign the declaration. I wonder if that's really a fair characterization of the conversation, because I'm skeptical it's a fair characterization. Which you should be. You should be skeptical because it's written in the best possible light. So when you're thinking things, you're like, that seems a little odd. So I'd be interested to see if Saltz agrees. The undersigned asked the obvious question. If Barnhart told counsel she suffers from foggy thinking, poor memory, and confusion, so she's incapable of telling an accurate story, why do they believe the account they provided them was accurate? The answer, Barnhart seemed clear-headed to them while she's telling the story they wanted to hear. Also, they assured the undersigned that while Barnhart told them that she'd taken medication that makes her unable to concentrate, think clearly, and remember things, they rushed to complete the interview and get her signature. I'm skeptical of that description. I'm not going to credit it because I'm very much interested in what Saltz has to say here. So I'm skeptical of this. The explanation only confirms the recklessness and bad faith. Reasonable attorneys acting in good faith would not have procured such testimony from a self-described impaired witness who contacted them after a 3-week campaign of harassment, was desperate for the campaign to stop, and was telling them a story that was flatly contradicted. I don't know. I'll be very interested what Saltz says. Nor would a reasonable attorney acting in good faith believe that Barnhart's condition or medication rendered unreliable stories she told during exchange of 150 emails over an 18-day period, but suddenly it became reliable. Yeah, I mean, I'm kind of with Brown, and I say that extremely tentatively because I'm not ready to credit this, because of the animosity between the attorneys. So if what Brown is saying is accurate, then I'd agree with Brown, but I'm not ready to credit it. And that's not to say I'm discrediting it. I want to see what the other side has to say because of the animosity between the lawyers. I'm skeptical. So I'm not saying it's false. I'm not saying it's wrong. It might be true. I'm skeptical. And there's been enough animosity here to raise skepticism. And of course, everything's written in the best possible light. So I would be surprised a little bit if Saltz agrees with this, and will be in a better position to judge. But I'm not really ready to credit this explanation. So we'll see. That's where I'm sitting. I don't credit it. I want to see the other side. In addition to any other sanctions the court deems appropriate, it should award sanctions in the form of attorney's fees. Defendants have forced them to incur fees. The multiplication of these proceedings is no doubt part of the motivation. Okay, and so we want fees for that stuff. Okay. I'm skeptical at best. I'm skeptical at best for two different reasons. First of all, this is wildly off point. I think it's a little unnecessary. So even where I'm like saying there's some things here, I don't think there's really anything here. Because I would not be pulling this trigger at this point. It would take a lot more for me. Because this is, again, just the animosity that we've seen very early in the case that's unnecessary. And Brown is not attempting to put it back in the box. And I think Brown should be attempting to put it back in the box especially because of what the judge said. And Brown is not trying to do that. He's trying to keep it outside the box. So one can only assume it's a strategy, that he has a plan of trying to put Saltz off balance. But I just personally find it unprofessional. The rough equivalent to this would be a teacher the rough equivalent to this would be a teacher who's always dismissing you and saying that you won't amount to anything, and then you amount to something, and then tries to say, well, I only told you that because I wanted to give you motivation. Like, it's like, no, I'm not buying it. So I'm not sold on this anyway. All right, so let's read some more stuff. I'm skeptical. It's unwarranted, and I don't fully credit it. So then we want we have a proposed motion that they've engaged in bad faith, and we want damages of the amount of whatever. So that's the end of that thing, a proposed motion, which will definitely not be signed, I guarantee you. If this is going to happen, which I doubt, the judge is going to write their own. So now we have a declaration, so let's read this declaration. No. Yeah. I think Brown has been more the aggressor than Saltz. I said, and I'll say again, that I think Saltz started the party. He was the first one who did the bad faith thing. So he might have very well spurned this. And so I still think, even after all this, and this is a personal opinion again, but I think Saltz has to be the bigger man and try to apologize and put this back together. You know, I agree Brown has done more, but Saltz was the first one who started this, and he's the one who has to end it. You know, he's the one I don't really think he can point and say, well, they did more. I think he has to be the bigger man. Now, it's a personal opinion. I think Saltz has to try to put it back in the box. And I don't know if that's possible or not, but I think Saltz has to try. That being said, however, I think Brown should be trying too. I think Saltz has an obligation to try. I think Saltz has a moral obligation to try. So I think Saltz has a moral obligation to try, and I think Brown has a professional obligation to try, if that makes sense. Brown's the one who started this party. It was unnecessary. But Brown should be the bigger man and try to make it work anyway. So I think Saltz has a moral obligation and Brown has a professional obligation. And I really do not like this attack on the other side. It's unwarranted. So let's read some more stuff. And we lost some people. That's fine. I mean, no disrespect. People like Emily, and they should. She's a good presenter. Emily is interesting to me because of how different she is. And this is not a slight. I want to make this clear. This is not a slight. She reacts things in a more emotional way, and that's fine. Different people react to things differently. I'm happy with the way I do things. She's happy with the way she does things. We're different people. It's okay. But some people like her better, and that's okay. You can like her better. It's not a big deal. You know? I'm happy with what I'm doing. If you like me, that's great. I think we all need to stick together. All right, so Brown, here's what Brown has to say. I'm a lawyer. I engaged in a meet and confer counsel with Saltz and some other people. During the call, Barnhart told them she's represented me in relation to this. They confirmed that she gave them access. I asked plaintiff's counsel why they procured sworn testimony from a witness. They explained that Barnhart told them that she's confused. It explains why she told a false story. The undersigned then asked the obvious question. Why would they credit it? Because she was clear-headed? Is this really the story Saltz is going to tell? I'm skeptical. Barnhart and the undersigned discussed the possibility of submitting a declaration. Yeah. Uncivil's more cute. Well, I'll take that for sure, because I am looking, ladies. Contact me on Discord. Saltz's threatening message, baseless accusation, limited nature of a relationship. That's true. She has two minds. Okay. In the second declaration, plans attempt to excuse the withholding, in part by claiming it contains private information. That's true, they did. That's simply false. Attached are true and correct copies of every one of the 9 emails that are characterized in the declaration. Not one contains words of health. That's kind of true, kind of not. I mean, Saltz was taking a more conservative position, and you took a position within the bounds, but I think both are acceptable. As the court is aware, defense have taken steps to file and unseal those relatively small numbers of emails that did have that declaration. They request fees for 41.9 hours spent. Okay, so that's like, hold on. What is 49? Excuse me. Strike that. What is 41.9 times 450? 18,000. So this is a $20,000 request. Okay. The 41.9 hours includes task-related filing, such as research. It reflects my review of the documents. I've also excluded time for associate attorneys and paralegals. I've included only 33% of the time because of communications several issues. Attached is a true and correct copy of my invoices. My standard rate is $450, which I believe to be a reasonable attorney's fees. I graduated from UC Davis. I clerked for the United States District for Eastern District, and then for Chief Judge of the United States Court of Appeals. Practiced civil litigation. Currently a partner. $450 is a reasonable fee. I agree. My partner charges $475. Yeah. I agree that's a reasonable fee. For a partner in a law firm, $450 is a reasonable fee. Attached is an Exhibit E with these declarations. Okay, and then we got some stuff. Exhibit A. This is from Michael Brown to Sue. Who's Sue? I spoke with Saltz today. They're planning to subpoena your Twitter account because they see you close your account. They think there might be evidence between you and Katie. I did not disclose you and I are in touch. So this is Lorianne. Is Sue? Hello, Lori. What the Westbrooks do you is shameful. We've seen that before. I made a signature page, so you don't need to re-sign it. I saw that before. Serving a subpoena. Saw that before. You used to volunteer. We've seen that before. Here's how it plays out. We've seen this before. Done nothing illegal, yes. I don't see anything to get you in legal trouble. We've seen this. Can you please talk with me before anything? We've seen this. Exhibit B, and then we have the accounting of hours with an unredacted version, presumably to the court. Emails with client. These are by the way, these are 1/10 of an hour increments. These are 6-minute increments. That's how lawyers typically bill. So if you're wondering what's 0.3 or what's 0.5 or what's 0.1, 6-minute increments. That's how lawyers bill, is in 6 minutes, 1/10 of an hour. So everything the lawyer touches is $45 minimum. Emails with the client, half an hour, sounds reasonable. Telephone call, research declaration, research, review, emails with the client, emails, preparing the declaration, 4.8 hours. That sounds about right. Emails, preparing under seal, prepare this, 2.5, yes. Prepare, 3.5. Client, yeah. Prepare, do this stuff, Meet and confer, motions. Revise, prepare motions. Prepare sanctions. Prepare sanctions motions, 5 hours, really? Is that a 5-hour motion? It seems a little excessive. But okay. Revise sanction motions, 2.5. Yeah, and that's the Exhibit C. And then we got some other stuff dealing with attorney's fees, presumably. Seattle versus truck. Why are these emails to a different name? Lorianne apparently used a bunch of different names, and Katie Joy used different names. I don't know, but that's what it is. So this is just this is case law dealing with attorney's fees. Okay. Blah, blah, blah. Hourly rate. So this is just showing this is a valid hourly rate. 450 seems like a valid rate. So yeah, this is just a prior case that shows this to be an valid hourly rate. So that's fine. And then we got another case dealing with whatever hourly rate of $5.25, $4.95. Yep. So this is just showing prior fees as being reasonable. Exhibit E. So now we're trying to show the contrast between the declaration and the email. So I think we should spend some time on this. The declaration, the reluctance to sign the declaration. She did ultimately not sign it. First declaration was prepared with a 1,500-word personal statement. Yes. Nothing in the first declaration is inconsistent. I don't think so either. The Barnhart reviewed and approved each draft of it. That seems to be true. Barnhart conduct leaves no room that she was anything but eager. That's very true. I agree with Brown. I agree with Brown here. That isn't, of course, to say I won't also agree with Saltz later, based on his characterization. But this characterization is a fair characterization. He's being fair in the way he's doing it. So I may or may not agree with Brown later. We'll see. But the way that Brown is describing this is a fair characterization in my view. Barnhart objected to the fact that the declaration was malign. Barnhart never objected to anything. It was eager to sign it. Seems to be true. The emails, far more limited terms. I agree. That is a fair characterization. Yes. Saltz did not threaten me. Barnhart's immediate reaction was more threats directed at me. That seems to be true. Basically telling me cooperate or else. Seems to be true. No one has the right to threaten me with legal action has done this. I can't believe in the world we live in. They can threaten you, just have to step up and take it. Those are direct quotes from him. I mean, you can't contest that. Those are direct quotes. I can think of reasons that from Saltz's perspective, this is fine. Right? So from Brown's, because we have to put ourselves, this is where you have to engage in a little bit of abstract thinking. You have to put yourself in the position of Brown, and then also put yourself in the position of Saltz. What did they know? What didn't they know? What was their perspectives? What were they considering? Right? So this is all valid from Brown's perspective. But I can think readily off the top of my head without blinking an eye about what Saltz is thinking or what possible things you're thinking. I think, because I don't know, because we haven't read it yet, right? We haven't seen a response. But at least in my own mind, I can conjure possibilities. And I'm like, okay, if everything Brown says is true, what are possibilities from Saltz that make Saltz what he did okay and make what Brown says okay? How can I reconcile that? And so I'm putting myself in two different mindsets at the same time. I'm putting myself in the Saltz mindset and in the Brown mindset simultaneously, which is one of the advantages of being in the middle, because I can do that, because I can be objective, or at least I can switch perspectives. So I can simultaneously consider things from multiple different viewpoints. And I'm like, okay, all this makes sense from Brown's viewpoint. If I'm in Saltz's shoes, however, how does this look? And I can conjure possibilities. I'm like, okay, that kind of makes sense from Saltz's point of view. So I'm like, okay, can I conjure a scenario in my own mind where Brown is right and Saltz is right? Yes, I can. I can make it work. And that's one of the things you got to do when you're trying to, especially as a lawyer, because it really pays to put yourself in the opposite mindset. And you can't always do it, and you got to try. It's hard. And I'm not perfect at it by any means. Especially when you're in it, it's really hard. It's a little bit easier for me in my position because I'm not in it. If I'm in it and trying to conjure what the other side is doing, that's hard because I'm trying to also overcome my own biases at the same time, and that's really fucking hard. But you got to try. Because you got to think what they're thinking. You got to feel what they're feeling. You got to predict what they're predicting. You got to be able to see where they're going before they get there. It's kind of like a general in a war, a little bit. I mean, like, doesn't a general in a war want to know what the opposite side's general is going to do? Don't they want to predict possibilities? Of course they do. And that's kind of the same idea. It's like, Put yourself in their shoes. What do they know? What don't they know? What is their thinking? What are possibilities? How do you prepare against that? And sometimes you predict right and sometimes not. It's a little bit easier when you're abstract from it, which I am, because I'm not in it. So it's a little bit easier for me because I can just, because I don't have to overcome bias of being in it. But you have to put yourself in these mindsets and try to think what's true, what's not true. What does one side know? What does their side know? What are the possibilities here? And vary between those. So I'm like, okay, all this makes sense from Brown's point of view. Can I think of scenarios that makes Salt's not look like a jerk? Yes. Does that mean Salt, because Brown is right, does that mean Salt is wrong? No, it doesn't. And these are things you got to try to do if you're really trying to look at this as fairly as possible. And I'm not perfect at this. And again, I'm not trying to claim I'm perfect. It's not trying to claim I can see everything. I know for goddamn sure I can't see everything. There's things I can't see. I'm surprised too. I'm not perfect, but you try. And you do as much as you can to open yourself up to possibilities. And that's one thing that law school really does for you better than anything else. Even better than teaching the law, maybe. One of the things law school really did for me was teach. There's a great book that you read as a 1L. Was like The Answer to Everything is Maybe. I can't remember the name of the book. It's like, yeah, but the answer to everything is maybe, and it just teaches you the ambiguity, and it's really helpful. And trying to think about multiple different perspectives. So, just because Brown is right doesn't mean that Salt is wrong. It's not necessarily zero sum. Barnhart acted as an agent and bulldog. Paulson never said they asked to do anything for her. True. Cades never asked to do anything. True. That's right. That is what Lorianne said. Marriage with Paulson has been limited. That's true. That's correct. That's in keeping. Paulson also always knew Barnhart resided in Washington. I have no reason to believe Paulson knew where I lived. That's true. That's in keeping. Barnhart explicitly confirmed that she had no reason to believe. That's true. Barnhart stopped supporting Paulson. There's so many Twitter tubes I support because it got so bad. That's true. Yeah. So Brown is right. Doesn't mean that Saltz is wrong. I'm dually skeptical here because this seems to be getting personal between the attorneys. I wouldn't be quite as skeptical if it hadn't gotten so personal between the attorneys, but it has. So I'm a little skeptical here that this is an accurate reflecting of what the conversation was. I'm not, again, that isn't to say that he lied. It isn't to say that his declaration is false. That's not what I'm saying. I'm saying different people have different perspectives. I'm a little skeptical. Every word of what Brown says could be true from his point of view. It may not be the end of the story. We'll see. Barnhart also communicated with Paulson. We've never spoken on the phone. She's never emailed me. Again, that's a fair quote. Construed from the very interaction. So Barnhart mistrusted me from the very first interaction. No, you didn't. Here's how you do it. Yeah, I mean, that's true. That's true. From Brown's perspective, everything Brown says is right. Barnhart was uncomfortable. The second declaration admits this. Yeah, I mean, this is just going to show that what he did was reasonable, and it is reasonable. So Brown is right. So it will be interesting when Brown responds, or when Saltz responds. It'll be very interesting to see how Saltz deals with it. Because Brown's perspective makes total sense. It makes total sense. Brown got that completely we read it together on channel. We read the entire thing together. Brown had that unsolicited 2,000 word explanation. The declarations were in keeping with that. He offered to make edits. He did make edits. Lorianne was eager to sign. She did say all those things. We read it together. She wanted to go to the store. She wanted to get the ink. She was looking for signature apps. She was trying to do everything. And then she fell off the face of the earth. It's a little unclear why in the record. So it's a little unclear because Brown is sending all these messages with no response. Lorianne kind of ghosted him. So you can infer some things, but we don't know. And we don't know for sure what the conversation was with Saltz. We know how it ended up in the end, and we don't know what emails Salt's had. So, you know, I understand Brown's point of view. I don't quite understand, personally, why he's not affording a little bit more benefit of the doubt to Salt's. I don't understand quite why he's filing this. And if I'm the judge, I for sure as hell don't care. I just don't care as the judge, because none of it matters to the issue, which, once again, jurisdiction. I don't understand completely what Brown is doing here. Brown seems eager to increase the tension between him and Salt's, and I don't quite understand why. Particularly after the last hearing between the judge, because although Salt's did get whacked more, the unspoken message was both of you behave, and Brown should be able to pick that up. And he's not doing that, and it's a little bit weird. So I don't know if he's trying to put Salt's off balance or what, but it just seems, or if he's just trying to increase fees or what he's trying to do. It's just a little bit, I don't know. But let me take some questions for a while. Let me just scroll up and I'll take some questions. Actually, let me not scroll up. Let me just take questions from here on out, okay? So let me just remove the filter and we'll make it completely unlimited chat, and I'll try to deal with that shit. So slow mode is off. Ask questions, and I'll try to answer them as best as I'm capable. So let's do some Q&A for a while, because I got 30 minutes before I have to talk to Nate for my weekly stream. We delayed it an hour so I could talk to you. I'm still doing my weekly stream with Nate in an hour, or a half hour. But I want to talk to you guys, so ask me some questions. I'll try to give you some answers as best as I can, which may or may not be the final truth. So I'm just going to start from now. I'm not going to scroll up. So what questions do you have about this case, preferably? Yeah, we'll be on Nate's channel in a half hour. Yeah, we'll be on channel in a half hour. Has jurisdiction been decided? No. Will there be an oral hearing? I don't know, but no if it's me. What's the answer to life, the universe, and everything? 42. The stream with Nate will be on his channel. What happens next? The thing that will happen next is most likely is the decision on jurisdiction. What's the point of this filing? I don't know. What's the average estimate for when jurisdiction will be decided? The average estimate, 3 months ago. While I'll talk about fees, I don't know. Any idea when there will be jurisdiction? Soon. Does Salt's have to respond? Technically, yes. Isn't what the judge told them to stop doing? Yes. Do I think the repeated dragging of Emily is a way of staying sage to sue her? No. I don't know what the point of it is. I don't know why they keep mentioning her. Can I anticipate the judge's reaction? I can anticipate my reaction. I don't know the judge well enough. Do I think that breaks the spirit of what the judge told him? Yes. Is this preemptive strike on Brown's part because of the hacking response? Don't know. Is this something that Salt's could ignore? He needs to respond to it. Can we get a cat filter? I am not a cat. How do you think Salt's would respond? I don't know, but I'm looking forward to it. Do I agree with Poppy Seeds? There will be certain fees? Could be. Is it likely the judge will be unhappy? Probably. Did Brown deny that he represented Lorianne, now saying he's in? He's trying to have it both ways, Joanne. That's for damn sure. He's trying to have it both ways. Have you considered going full ZZ Top? No, I'm trying to keep it trimmed. What's my reaction? My reaction to this is a lot of bullshit. Can Emily get in trouble for nicknaming Brown as Brown Sus? Not really, no. She's an opinion channel. She's fine. Do I have family? I have one younger brother. Am I familiar with reference of KJ's merchant response joyfully unavailable? No, I'm not familiar with her merchant. Does determining jurisdiction really take this long? No, because there's been a lot of bullshit in this case. It shouldn't take this long. Do you think mentioning Emily to try and prove Salt's is trying to destroy KJ's business? I don't know what the point of mentioning Emily is other than to say it's getting press. So I think the only point is to say it's getting press and attention, and so it's defamation by proxy. If KJ wins her part of the case, can KJ go after Toddy Westbrook in the same way she did before? If KJ has counterclaims against Toddy, she can always bring counterclaims. So I'm not sure exactly what those be, but yes, KJ can sue Toddy if she has causes of action. Do I think Brown is pissed and just wants to recoup for Lorianne wasting time? I don't know. Does Saltz have to respond to this? Strictly speaking, he doesn't have to, but he should. If Saltz keeps filing unnecessary things, could Toddy have to pay Katie's legal fees? I seriously doubt that result. I do not believe this motion will be granted. Why does Saltz have to be responded? Because, I mean, he doesn't have to, but he should. Because he's been attacked and they want money. It's all a pain in the ass. The judge's head is in a swivel? Yeah, I agree. Yeah, the book I mentioned, Getting to Maybe. That's right. Getting to Maybe, How to Excel on Law School Exams. That's right, Jennifer. It's a classic. So the book I was referring to when I was saying it was a good book that taught me a lot, the book was Getting to Maybe, How to Excel in Law School Exams. Yeah, that was a really good one that started my journey. It isn't the end all be all, but it started my journey for sure. If Brown is, after all, Lorianne's attorney, hasn't she waived privilege by sharing their communications? Maybe. That's a whole separate analysis. Are we getting to counter sanctions? Do I think Saltz will respond succinctly? I don't know. What did I have for dinner? I haven't had dinner yet, to be honest. How long does Saltz have to respond? No particular length of time, but we'd expect it's Wednesday, so end of the week is realistic. Do I think a cost order is on the table if judge takes Brown's claims? Not this judge. She doesn't seem to be interested in that. How much does filing cost? This filing? I think it was in the declaration, but it cost a couple $1,000s, it looks like. At $450 an hour. I think it was in the numbers that we saw. So how much did it cost? Let me see if I can go up to the billing. 5 hours, 2.5 hours, that's 7.5 hours. Plus 1.5 hours is 9 hours, 9.2 hours. So at least 9.2 hours. So what's 9.2 times 450? It's about 9 times 45 is... So it's about $4,000, give or take. The Saltz have to reply to it? No, but they will. I'm on 6535? Yes. You know why I'm still on 65 poppy seeds? You know why I'm 6535? Because nothing concerning jurisdiction has happened in quite a long time. This has all been a lot of bullshit. I'm still 6535 because nothing has happened that would move the needle for quite a long time because all this is bullshit. So yeah, it's still 6535. 4140, yeah. I did my math correctly in my head, give or take. I said 4,000 and it's 4140, so close enough. Not bad when you're drunk to be able to do math and come up with the right answer, right? I said 4,000 and it's 4140, so it's close. How much has each side spent so far? Fucking too much. God damn, this is too much bullshit. What can you make me for dinner? Whatever you like, baby. Question: should Saltz be on Twitter responding to YouTube channels that have implied witnesses behind all death threats? Probably not. I think Saltz should confine himself to the formal filings. That was the last order specifically. Can we sue KJ for pain and suffering? I don't know. I don't know enough about your cause. But if it's generalized, no. What justification do you think was made for KJ in order to have this document filed? I don't fucking know. This doesn't make any sense. Do I have a P.O. box? Yes. The description, my description below has my address if you want to send me stuff, Aaron. It's in the description of my videos. You can send me stuff. Yes, I do have a P.O. box, and the description contains my address, Aaron. So if you're interested in sending me stuff, yep. Kimberly says, I think it's the glass you sent me. It is the glass you sent me, Kimberly. Isn't it such a nice glass that Kimberly sent me? So it has this wonderful little justice scales on one side, and then on the other side, it's got these wonderful little markers for how bad my day has been. Right? Can you see that? I don't know if you can see that or not. But It says, good day, bad day, don't even ask. So Kimberly, this was a fantastic gift. Thank you very much, Kimberly. And Kimberly also sent me a sign that says bang head here. But unfortunately, it's a metal sign. So if I did that, it wouldn't go well. But it was very humorous. Thank you. This was an awesome gift from Kimberly. Nice little tumbler for my drinking. And it's got the scales of justice on it. I mean, jam. It's got scales of justice. What more do you want in your life? You know? What size shirt am I? Double XL. If you want to know what collared shirt I have, then in 1934. Acid etch or paint, I don't know how it's made. Is it possible KJ runs out of money? I don't know where KJ is getting her money from. It's been speculated she's getting it from the business partner, which is possible. Yeah, please remember to like this stream. 504 likes. Please remember to like it. Please remember to subscribe. If Salts has to pay legal fees, does it come from Toddy's pocket? Depends on the nature of the sanction. It depends on the nature of the sanction. But it's possible for the judge to sanction Salts directly, in which case he has to pay out of pocket. What's my favorite kind of whiskey? I like bourbon. My favorite bourbon is Four Roses small batch. But I like Blanton. I love Eagle Rare. That's a great one if you want to get me as a gift. Knob Creek, Bullet. These are fantastic choices. Do an unboxing. I usually do them on Tuesdays, Christina. I do them. It's not necessarily an unboxing, but on Tuesdays during the Q&A, I do make a point of recognizing the gifts. So every Tuesday when I do the stream, I do make a point of it. It's not necessarily unboxing because I want them to see what it is. But yeah, every Tuesday I do make a point of acknowledging the gifts I received. Am I drinking out of a beaker? No, I'm drinking out of a rocket glass. What's your problem? Will Nate be mad at you that I'm already drunk? I don't really care. Nate loves me. What's the difference between Scotch and bourbon? Well, both Scotch and bourbon are whiskeys. Scotch is a whiskey that's made in Scotland. Bourbon is a whiskey that is made in the United States and also has some other requirements. But yeah. But Scotch has to be made in Scotland is the primary one. Bourbon has to be made in the U.S., has to be 51% corn, has to be bottled at not less than 80 proof, has to be aged in new white oak. If you want to call straight bourbon, it has to be aged for at least 2 years. And there's some other requirements too. Do lawyers have malpractice insurance? Yes, they do. How much do I have to send you to get to reply to my Discord DM? Send me another Discord DM. And I'll respond to it. What's my favorite barbecue joint? Someone said. Oh, man. So far, Salt Lick was pretty good. Okay. Yeah, DM me again and I'll respond to you. Let's see, where was I? I'm sorry about that. I got a little bit distracted. Willet bourbon? Willet is good. Discount storytelling. Do I think salts or brown gives a better legal argument? If we remove, okay, we have to do a lot of different things. But if we remove the attacks against the other attorneys, and we take out of consideration the initial motion to dismiss, which was a train wreck, they're both about even. But I'm a bit sucker for the way Brown does things in sort of the imagery. So I do like the imagery of Brown. But yeah, that's about that. LRW Design says bourbon whiskey is a Kentucky thing. Oh, no, my friend. Our LRW is wrong, my friends. LRW says bourbon has to be in Kentucky. I'm afraid not. It is defined in U.S. law and only has to be made in the United States, not just Kentucky. Now, 95% of bourbon does come from Kentucky, but this particular bourbon comes from Tennessee. And technically speaking, Jack Daniel's is bourbon. It is because it meets all the requirements of bourbon. I bet you didn't know. They call themselves Tennessee whiskey, which they are. because Tennessee whiskey has other requirements. But technically speaking, Jack Daniels is a bourbon. Ooh, it's from Tennessee, so there you know. So the more you know, and the more that you read U.S. code. Dog or cat person? Dog for days, man. How many drinks did I have for the stream? Not enough. Uncivil Law is feeling better today. Uncivil Law is feeling better today. I've told you guys. I suffer from depression, and as anyone who suffers from depression knows, depression is not rational. It hits you different days. Yesterday was a low day. Today I'm feeling a little bit better. Is there any reason behind that? Nope. I'm feeling better. I'll take what I got. Jack Daniels whiskey is technically bourbon. Yes, I know. They're Tennessee whiskey because Tennessee whiskey has additional requirements. But if you look at the legal definition of bourbon, they meet every single definition of bourbon. They do. You look up every single definition of bourbon, they meet every single definition. So they're bourbon by law. I know. I'm Are me and Emily still friends? Oh, absolutely. We're still friends. We worked it out. Yeah, depression sucks. Depression does suck. Feel bad. Last people were piling you. Most were just concerned. I appreciate that. Do I feel weird when people call you by your name in streams or prefer Uncivil? Either one's fine. I don't make a big point of knowing my name. My name's Kurt. It's not a big deal. K-U-R-T, by the way, if you want to spell it, because people misspell it. It's K-U-R-T. It's German. C-U-R-T is Greek. So screw the Greeks. K-U-R-T. Here's some etymology lesson for you for the day. C-U-R-T comes Curtis. It's Greek. K-U-R-T comes from Conrad. It's a completely different etymology. Serious. Look it up. And K-U-R-T means wise counselor, which I am. So, respect me. But either one's fine. All right. Well, it is 10 minutes before my stream with Nate, the lawyer. So if I could kindly ask you, if you'd be so kind, in 10 minutes, I'll be live with Nate, the lawyer, on his channel. It's called Nate, the lawyer. I know. Please go there and check it out. We'll be talking about impeachment and some other things. Will be great. But I need a little bit break before we do that, so you understand. This has been wonderful. So if you could go check out Nate, the lawyer, in 10 minutes, that'd be awesome. If you've not done so already, please like my channel. Why aren't you liking the video? Please. The YouTubes, I need the like. Please subscribe. There should be a link that's coming by from time to time. Hit the join button. 99 cents and all the rest of it. Did I tell you to check out Nate the Lawyer? Yeah, I did. Till later, my friends. Cheers. Goodbye.